the third time in this lecture series, I will be sharing in a little more depth another source of international law mentioned in the very first video, international customs. In this lecture, we will be asking 4 questions. What are international customs? Who is a persistent objector? How do international customs become law? And what are some examples of international customs? First off, what are international customs? Customs themselves are long established standards, norms, and practices of a community. International customs, on the other hand, therefore, refer to long established standards, norms, and practices in international law. International customs have a very important role in shaping international law. So according to the statute of the ICJ, international customs are a primary source of international law. International customs form a body of international law known as customary international law. Customary international law possesses a very distinct feature from international conventions as a source of international law. So we talked about international conventions in the previous video. In that video, we did establish that treaties are binding only on state parties who, by being parties to such an international treaty, expresses its consent to be bound by the tenets of the treaty, except to the extent that they have expressed reservations. Customary international law, on the other hand, is binding on all states. So that's the one distinction between international conventions as a source of international law and international customs as a source of international law. Also, we previously mentioned that the concept of consent is a very big principle under international law. So thinking about customary international law binding on all states, it will negate the principle of consent that we already established in our previous videos. The one avenue available, however, to non-consenting states is by the state party becoming a persistent objector. So next off, who is a persistent objector? We did mention already that international law leans heavily on the positivist doctrine that sovereign states can only be bound by norms that they consent to, and as such, can only have obligations and derive benefits from norms of international law they have explicitly accepted. Having established that the notion of customary international law seems to run at variance with the idea of consent, the notion of consent becomes somewhat problematic with regards to the bindingness of international customary law, where such norms and practices that form international customs have not been codified. So the one way that has been recognized under international law theory for getting around this situation for non-consenting states is for the state to become a persistent objector. Now, a persistent objector is a non-consenting sovereign state which has clearly and relentlessly objected to a practice or norm of customary international law since the norm's existence and considers itself not bound to observe the norm. It is important to note that for a state to be a persistent objector, it has to establish clearly and relentlessly that it objects to a set of norms, practices, or principle under international law right from its very existence. So despite its criticisms, the principle of persistent objection, which is beyond the scope of this lecture, adds flavor to the development of the sources of international law. As many authors have stated, it allows states to exempt themselves from the majoritarian tendencies that have been identified as having come to characterize the process of creating customary international law since the middle of the 20th century. It is important now to unpack how international customs actually become law. We already established that the statute of the ICJ states that international customs are a source of international law where there is evidence of a general practice accepted as law. The central issue then becomes how are these customs recognized and what is the appropriate technique for determining which norms and practices constitute customary international law. The central determining factors are cumulative, so it has to be both factors. One, state practice has to be established. In addition to that, opinio juris has to be established. And we will look at these factors briefly. So, state practice refers to a factual basis of the existence of certain legal practices. So, this is a material fact. The mere existence of certain legal practices by a few states will not suffice. In making the determination that there is state practice, a number of factors have to be considered. So, in terms of this practice, how consistent is it? Do we see a repetitive pattern? What is the duration of this practice? How long has this practice been in existence for? And generally, what is the behavior of states towards this practice? These are very important factors in determining whether a state practice has emerged. The decisions of the ICJ reflect that for state practice to be considered binding, such practices must amount to constant and uniform usage, or they have to be extensive and virtually uniform. So, establishing practice among, for example, 10 nation states may not be enough to establish that there is state practice, right? So it has to be extensive. And there has to be uniformity across board, right? Where there are slight variations in terms of how the practices are performed or what the belief of states are, then it can be stated that there is no uniform and constant usage. So it's important to determine state practice. It has to be uniform, it has to be constant, it has to be extensive, there has to be consistency, there has to be some sort of repetition, and this practice or usage should have gone on for a relatively long period of time. So for the second factor, which is referred to as opinio juris, it is important that after establishing practice, it is also necessary to establish that the practice in question is accepted as constituting a legal obligation by practicing states. It is important to demonstrate an opinion by the practicing states that an act is necessary by rule of law. As the ICJ puts it in the North Sea continental shelf cases, the practice in question must have occurred in such a way as to show a general recognition that a rule or legal obligation is involved. Quickly, we'll take a look at examples of norms and practices that are recognized as customary international law. For For example, in the ICJ case of Nicaragua versus the United States of America, that is the case in the military and paramilitary activities in and against Nicaragua, the ICJ held the following principles to be binding as part of customary international law: non-use of force, non-intervention, respect for the independence and territorial integrity of states, and freedom of navigation. Other examples of customary international law that have been recognized: immunity and non-refoulement. So it's important to note that over time, many of the principles of customary international law have been codified into international conventions. For example, the customary international law norm of immunities have largely been codified into the Convention on Privileges and Immunities, Diplomatic and Consular Relations. Just to recap, we have unpacked what international customs are, who persistent objectors are, the factors relevant in determining how international customs become law, and we have given some examples of customary international law. So I want to thank you so very much for joining in, and remember to like, to share, subscribe, and hit the notification button so that you're notified when there's a new video. Thank you.